Hey, Glenn. Hello. We're just waiting for a few people to join, and I think we'll get started fairly soon here. All right, I think we'll go ahead and get started. Thanks, everyone, for joining. We appreciate you guys being here. I just left this in the chat, but if you guys have any questions for me or things that you want to talk about or discuss, anything like that, feel free to leave that information in the chat, and I'm more than happy to address those things and see how many questions I can answer. I'm sure you guys have plenty of those. I would also love to hear about the things that you guys are working on. From sports tech is the topic of this webinar, but I'm sure there are lots of different subcategories within that, right? So there's apparel, there is data analytics, there is software, there is hardware apparatus. There's a whole gamut of things that can be covered by sports technology. So if you want to give me a quick update on what it is that you're working on, I can try to direct the webinar to those topics that are of specific interest to you guys. So don't be shy. Leave those questions. I expect this to be, not just a one-way conversation, but really a two-way conversation. So I can direct this and take it in any direction that you guys find interesting or is important to you guys. I'll start with a quick introduction on myself. I am Summer Shah. I am a patent attorney. Um, and my background is mostly in large law firm and corporate law. So I have written patents for companies like Facebook and Google and Honda and a bunch of other kind of big name tech companies. I started my career in Silicon Valley. and represented those companies. I did that for about 5 years and then moved into a litigation role. So I represented similar companies in high stakes patent litigation work, and took those cases to trial. I took about 5 cases to trial, and thankfully won them all. That's been an interesting process. And I did that for about 5 years and then shifted over to my current firm, Outlier Patent Attorneys, which I founded. We represent enterprise companies as well as tech startup companies, a lot of sports tech companies. So that has been a fun journey for us. And there is a lot that we talk about as far as startups go. And in my opinion, there's just not enough written about this topic. Like there's a lot of patent advice for enterprise companies, large companies, but there's very little about what startups can do and how they can navigate these waters. So that's one of the reasons I wanted to create this. In addition to being a lawyer, I am a part-time computer hacker or coder, I guess. And I've created some data analytics tools because there's also a dearth of information or analytics that are available to startups, right? So we went out and created them as we work with more and more startups and early stage inventors. So we have created a data visualization tool that helps you figure out, what are different people filing patents on. And it takes information from the CPC classification units at the patent office and plots them across this landscape map. We also have a patent visualization tool or patent valuation tool, which kind of gives you a rough idea of the market value of a patent based on historical trends. Happy to go into any of these if you're interested, but just kind of wanted to talk through them in case they are of interest. We have also developed a software tool called Patent Pending Made Simple. I kind of think of it as a TurboTax for a provisional patent application. So it's a low-cost patent application. It uses AI. It'll ask you a question or several questions about your invention, and then it uses AI and our kind of custom libraries and templates to generate a provisional patent application, which I think is a pretty high-quality application. You can see our pricing here for it. But relative to hiring an attorney, it's a much more cost-effective option. So I'm sure we'll talk about this some more, but if you have any questions, happy to answer them on these as well. And I see that you guys have posted some questions already. Yep, very good. Nice to meet you, Edward. Okay, no problem, Glenn. Nice to meet you as well. Yeah, I think this will be applicable to you as well from home improvement products as well. A lot of the underlying concepts are the same, and we can dig into some of the more specific things that you'd want to worry about as well as we go. So I'm happy to talk about this. But the first or the threshold question, in my opinion, is should I should I file a patent in the first place? Is kind of the first thing that I think about. Do I need a patent? And that is a question that every inventor has, but I think particularly for hardware apparatus and sporting goods technology patents, it can get very tricky because on the one hand, you do need to protect yourself, but on the other hand, you do need to get the product out in front of other people. So we'll talk about that in this webinar. If you do need patents, the next question is, when should I file patents, right? That's a timing related question there that you have to work through. So we'll talk about that too. At what stage is a patent the most appropriate, and how many patents do you need to file, and so on and so forth. Those are questions that come up that we'll try to answer here as well. And then the third question that we'll try to answer is, how should I go about the patent process, right? So you might have seen some companies will file no patents, right, whatsoever, and some companies will file 20, 50, 100 patents, right? Two very different approaches. There's no right or wrong way. One of the takeaways that I want you to walk away with here is that you really need to streamline your patent strategy to your business strategy, right? And think through that. So we'll talk about that as we go as well. What is unique about the sporting goods industry or the space is the number of stakeholders that you have to deal with, right? You have customers, like you got to get your products in the hands of customers. You have competitors. I mean, this is every industry will have this, but in the sporting goods space, often your competitors are giant companies. So you got to be really careful and keep an eye on what they're doing from a patent and an IP strategy, because they can um, you know, bury you with litigation or paperwork and things like that. So we'll talk about that. You have retail and channel partners. You have sports leagues. I mean, everyone is going to have to deal with this, but in the sporting goods space, you have organizations, associations that you got to sometimes get your products in front of for broader adoption. You have capital markets or investors, and then suppliers and manufacturers. So all of these things that you need to worry about in the sporting goods space. And of course, these are some of the giants that you're going to be dealing with in the sporting goods space. And then, of course, the leagues. These are some of the things that we talked about, right? So if you invented a new pickleball paddle, for example, you need to get it in the hands of players, but you probably also need to get it sanctioned by the leagues, right? So it's an interesting additional layer of complexity that you have to deal with. Okay, so so this is my framework for how you should think about a patent application. I think patents can be very important in some circumstances. So there is licensing to large companies. If your goal is to, develop a new racket and sell it to Wilson or Sporting Goods or something like that, you probably want to have patents protecting you, so you have something worth licensing. If you're going to sell your company to a larger company, patents are very important. Or if you are trying to get it sanctioned by a league like the NFL or the Major League Pickleball League, you need patents can really help you move those conversations along. It does give you a lot of credibility. Sometimes those leagues get pitched by so many companies that they may or may not be interested, right? So you got to get their attention somehow, get them motivated to do deals with you. And then equipping your small company with the firepower to deal with the big ones. Yeah, I appreciate that comment. It is very true. Because these companies, we'll talk about this later on in the webinar. I have some case studies about how some big companies have tried to bury the little guy, right, and take over their innovation. So that definitely exists in this space and many other spaces as well. Sometimes patents may be less important. I mean, it may seem odd for a patent attorney to say this to you, but patents are not the most important thing, believe it or not, in your startup journey or your market adoption journey. If you're self-funded, if you have limited sales expectancy, like if you're going to only sell, let's say, and I shouldn't say only, but you're going to sell 200K worth of product over the next 10 years, maybe patent spend is not going to be worth it. I would maybe try to minimize my costs through provisional applications or through the patent pending made simple software that we talked about. If you're going to go the e-commerce route, a strong or an expensive patent strategy is not worth it often. You just need one patent. You need Amazon or Etsy or whoever as a platform to ban knockoffs, right? And if you have one patent, you can send that to Amazon, and Amazon will take down all your competitors. So I would try to get there as quickly and cheaply as possible with a singular patent. In those cases, maybe the content or the scope of the patent is not as important. Getting something protected and filed is important, and issued is important. So those are some of the considerations. Yeah, number 2 is a bit complicated. It's hard to figure out what the lifetime value is. The other way to think about this, guys, is what is the sale per unit, right? So if you're going to, like, let's say your product is going to sell for $5 a unit, and you can only self-fund, let's say 200 units a year, right? So that kind of gives you an idea of what that sales velocity or value is going to be. But if you're going to sell, let's say, a set of golf club for $2,000 or $3,000, even $5,000, right? And you can self fund 100 units. That kind of changes the equation a little bit. Also, your per unit profit margin makes a big difference from a IP perspective, just because you're going to have to sell a whole lot more units to make up for your IP spend and have a return of investment. But these are the kinds of things that I want you to think about: is what is your per unit profit margin? How many can you manufacture in a year? How big is the audience for this thing, right? So like if you have a very niche kind of a sporting goods product, right? Like let's say there's only 100 people who practice this kind of sport, then that tells you, okay, even if we sell to 100% of the market, it's not going to, I'm not going to sell 1,000 of these, right? But if you have a very large market, like if you're selling your product to like a baseball audience or baseball athletes, then that's a much bigger market. So also think about that too. How big is that market? And that will help you answer those questions. So I hope that helps. I know that number two is a little, the bullet number two is a little complicated. Okay, so this is our framework for how you should think about patents. And the way to think about patents is to first think about the business, in my opinion. So one, you want to understand what your go-to-market strategy is, right? Are you going to license this invention? Are you going to manufacture this on your own? Are you going to take on investors and try to get into retail partners, right? How are you going to get this product, out of your head or from a piece of paper to a consumer in exchange in some kind of commerce or transaction around it? That tells you a lot about how you should go about the patent strategy. And we'll talk about some of these options as we get further along in the webinar as well. But that's the number one thing I think you should be thinking about: is what is a go-to-market strategy? And then we talked a little bit about this already. Number two is, what is the sales volume and how big is this opportunity, right? How big is the addressable market and what percentage of the addressable market can you capture? And then what is your per unit profit metrics? The third thing to understand is, what are your competitors doing and what are the large companies in your space doing, right? That's very important as well. If you're in a very crowded IP space or a very crowded competitive space, and all of your competitors are filing patents, maybe we need to do the same, right? Even if it's not to protect ourselves, it is as a defensive asset or a counter assertion asset, right? We don't want other companies to kind of blow us out of the water with a patent lawsuit. And if big companies in your space are filing a bunch of patents, we do need to get some defensive assets in place to protect ourselves. Otherwise, these companies have nothing to lose, right? So if you think about this, like your size, even though it's a disadvantage for startups, it's also an advantage in some ways, right? So like if my startup client infringes a big company's patent, they could be on the hook for, let's say $10,000 worth of damages because they've only sold $20,000 worth of product. But if a big company infringes on your patent, right, they could be on the hook for $100,000 because they probably would have sold $200,000 plus worth of product, right? So if you want to, make those lawsuits go away from big company to you, having a defensive or counter assertion asset is critical, I think. So you've got to really look at what the IP filing strategies of your competitors, and what are they doing, and how can we situate ourselves to leverage that or protect ourselves. And then this is kind of a bonus part of the framework. I mean, we talked about this already, but one size does not fit all is kind of how I think about this. There's lots of different ways to protect yourself through a patent portfolio building strategy or patent filing strategy. You really need to consider 1, 2, and 3, like we talked about, in order to come up with an effective patent portfolio and drafting strategy. So that's our framework. I'll dig into each one of these. And maybe the best way to do this is through some case studies and how other companies have done this. So I'll talk about Theragun first and a few others next. But let me just pause here real quick and see if you guys have any questions or if there are any things that I can address. Okay, I think we are doing good as far as questions go. yeah, feel free to keep putting them in the chat if you guys have them. I'll try to do my best to cover them. Yep, and Glenn, I think you have a question on the provisional. Yeah, I think I'll ask you some more questions about it as we get closer to the Q&A here. The first case study that I have, let's see. Yeah, let me do this. Let me answer your question. So you have a question about authorization or rescission of authorization to permit access to application as filed by participating offices. Yeah, what is your question about this form? Could you give me a little bit more context, Glenn? Why don't we circle back to this? You may be typing, but yeah, give me some more context. I'm happy to answer that the best I can. Okay. So the first case study I have is the Theragun, right? You guys might have seen, Theragons are hugely popular, at least in my friend circle. We all have one. They really came into the public consciousness um, uh, in a couple of different ways we'll talk about. But their story started in 2007. Their founder and inventor had this motorcycle accident injury and was trying to find something that would help him alleviate the pain or help him on the road to recovery. So he started this product called a Theragun. It was a percussive massaging device. So they started in 2007 and really were just kind of puttering along until 10 years later, when the Cavs, the Cleveland Cavaliers, were in the finals against the Golden State Warriors, and Kyrie Irving's back kept spasming, right? So APC and NBA have these rules that like you can bring any device to the sidelines. Players are allowed to bring anything they want, but they just had to cover up labels, or like if it's a device, you had to cover it up with a towel. So like he kept on getting work done on his back with a Theragun 4 or 5 times, and every time they had to kind of cover up the product, and naturally like build intrigue, right? Because everybody's like, what is he using, right? Like what is Kyrie Irving using to deal with his back pain? Because if he's using it, it's got to be pretty good, and probably would help my back pain as well. And that's kind of when they kind of hit it big, right? They kind of came into the public consciousness, and they sold out. The founder said they sold out in a weekend, which is pretty amazing. So these kind of things happen. They take time, right? From 2007 to 2016. One of my favorite quotes is from Mark Cuban, who says that it took me 10 years to become an overnight success, right? So certainly true in the case of Theragun. And Theragun's a huge business now, right? They raised a $165 million funding round a couple of years ago. And I couldn't find, they're a private company, so I can't find all their revenue data. But in 2020, it's reported that they did $224 million in sale. In 2021, they did $396 million. And then in 2024 through July, it's reported that they've done $750 million in sales. So on their way to be $1 billion sales company. It's an incredible success story. But they're dealing with a lot of knockoffs, right? So if you ever, search for a massage gun or a percussive massage gun, you have seen all the different knockoffs that are out there. I just did a quick search. So Theragun, they sell this massager, the high-end one, for $600. And look at this, knockoffs on Amazon are selling them for $25. I mean, talk about getting undercut by the competition. And it always made me wonder, what what has Theragun done with their patent strategy, like to invite this kind of knockoff behavior? And they actually have this like triangular shaped massage gun now, but they used to have it. Their older version was looked exactly like the knockoffs, right? It just looked like a gun. Um, so I said, well, let's go look at their patent portfolio. Let's see what they've filed their patents on. So remember, they started the company in 2007, didn't file any patents until 2016, right? So for 10 years, they were operating as a small business, didn't file any patents, didn't protect themselves. Really seems like they started protecting themselves after they hit it big with the Kyrie Irving's finals publicity stunt, right? And then they filed, I know that our graph shows 10, but it's one patent that they filed in 10 different countries. And that's it. They were probably doing a bunch of, many millions of dollars in sale at this point, but didn't think to protect themselves. And that comes to bite them later, right? As you see with the knockoffs and things like that. And, they actually, the only patent that they filed in 2016 was actually very broad, right? So they try to protect, a motor, a percussive actuation motor in a handheld device, and they got rejected. Their first application, if you look in our chart, like the green is the number of patents that got allowed, and blue is the number of patents that they filed. They never got their first patent allowed ever. And they made a mistake that I think many early stage clients or inventors make. And they wrote a patent that was too broad. They try to capture the whole concept, right? They're like, oh, this is a lucrative business. We want to stop everyone from doing something like what we're doing. And they filed a very broad patent. And they got rejected. This patent got rejected 4 or 5 times before Theragun finally called it quits, and they just let it abandon. It never turned into a patent. And the patent office cited this Works kind of handheld hardware tool against them. So, to me, that's like the first lesson is that I know it is enticing and attractive to file very broad patents, right? But you really, really have to kind of understand what you're trying to get a patent on and what you're capable of getting a patent on, right? So you need to do some high quality searches and right size the scope of your patent to the market and to the prior art that's out there. So to me, that's the first lesson. I talk to my startup clients and my individual inventor clients all the time, is that yes, it is attractive to ask for the sun and stop everyone from creating every competing product there is. But that strategy seems to have backfired on them, right? Because now they don't have any patent protection at all. And meanwhile, the product itself is just blowing up, and they get into 2018 really still with no patents. I know this patents got allowed, but they actually got allowed later in time. Kind of a tough spot to be in. And actually, I kind of looked up their filing history. They ended up firing their patent attorneys, right? And ended up getting new attorneys because this was a misguided strategy, right? And I don't know who pushed for broad patents, whether it was the attorney or the client, but I certainly would not have done that, right? I would have started on the opposite end and protected the unique aspects that everyone is going to have to copy, instead of broadly protecting the concept as a whole. So this is where patent strategy becomes very important. These are some of the patents that they filed, but the big set of patents that they filed are on the design patents. So what they said is, well, we can't patent this concept that we have of a percussive motor inside of a handheld device, but they have all these different like knobs and attachments for different types of massage applications. And they filed design patents on the shape of those knobs. And they have a lot of patents now, but that's the direction they went. They went all the way to the other side, and they said, well, if you want to have all these attachments that have these unique benefits, you're going to have to go through us. And then they had to come up with a kind of a unique shape of their device as well, right? So this is version 2 of their device, which is a triangular device, and they were able to file a design patent on the triangular shape. So that's why you don't see knockoffs that are triangular in shape, right? You see knockoffs that are shaped like a gun. But if they had started from the very beginning and protected a massager that is gun shaped, these knockoffs wouldn't exist. They would have to look worse, right? They would, like, I think their gun, in my head, like when I close my eyes, I still think of a gun. It's even in their name, a Theragun. And they just kind of gave up that opportunity. So knockoffs have just kind of inundated them with products that cost less than 1/10 of what they want to charge. So they have a lot of patents now, but most of these patents are actually design patents, and that's kind of the way to go. They have some electronic patents on how fast the motor moves, or there's some like noise dampening that they do, that kind of stuff. Like that's probably fertile ground for patents, and not the broad concept. Okay, so that's one. I think case study. We'll come back to this because I think there's more lessons to be learned from Theragun and Therabody. But let me pause here and see what kind of questions we have. Oh, I see. Glenn's question is, if I don't want to, do I check box 22 or box 2? So actually, provisionals by default are not published at all, right? So as long, like if you don't file a non-provisional, the provisional will never be published and it will never be disclosed to anyone, and you can kind of rest assured that it's not in the public domain. If you file a provisional and then later file a non-provisional, the non-provisional will publish 18 months after the original filing date, and then the provisional and non-provisional will publish together. That form, the rescission, so that's for international agencies. So sometimes you don't want international agencies to have access to your patent for whatever reason. You don't want them to archive it. That's what it's for. It's not for keeping the provisional private. Provisionals are not published by default unless they're converted into a non-provisional, and then the non-provisional publishes 18 months after filing. Then the provisional will be published at that time as well. There are ways you can keep the non-provisional from even publishing if you don't want to, but the trade-off is that if you choose to not publish it, then you won't be able to file internationally, is usually the rule, because international bodies want you to publish in order to be able to claim priority to your earliest filing date. So yeah, that's for a different application, Glenn. No, so provisionals, you don't, most countries, like there's no international provisional application, so to speak. So you have to file your provisional in the US and it's not published. And then you convert it into a non-provisional, which does get published 18 months after your provisional filing date. And then if you file an international application or PCT application, those applications will publish as well at their scheduled time, usually 18 months later. And at that time, the international application, as well as the underlying US non-provisional or the US provisional, they will all publish at the same time. I don't know if any authority that will publish your provisional applications. I know that's true in the US, but and I think that's true in most international markets as well. But I am not an expert in international law. And I guess I should, caveat this by saying, I'm happy to answer these questions, but I'll also say this, that, this presentation, is intended to be kind of an educational forum, not intended to, provide legal advice to any of the attendees here. So, just keep that in mind. I'm going to try to answer your questions the best I can, but I'm going to try not to establish an attorney-client relationship, right? Because that's not the purpose of this presentation. It is to educate the audience, all of you guys who are attending. So Glenn, hopefully that answers your questions. Let me know if you have any others, or if that's not clear. All right. So, we talked about this, right? Patent strategy is not a one size fits all. You really got to take into account what you're doing, what is your business strategy, and then build a patent strategy that complements your business strategy, right? And companies will have different business strategies, and therefore they should have different patent strategies as well. So I think Peloton is a great example of this, right? They have been, I mean, they're obviously very well known and well funded at this point, and they have been very aggressive in terms of litigating on their patents, right? And stopping people from having this leaderboard system and all sorts of other things. So they file a lot of patent lawsuits over the years, right? So they filed a patent again, or a patent lawsuit against NordicTrack, Flywheel Sports, uh, uh, what is it? This is against Icon, or this is Icon, and then let's see, this one is against. No, I don't have that information. But if you Google them, you'll see all the patent lawsuits that they've filed. That patent strategy, if you're going to file a lot of lawsuits to secure the market and prevent competitors from entering into the marketplace, you need to file a lot of patents, right? And you can kind of see that they started off with a pretty patent heavy strategy. So in 2005, for example, Theragun had 0 patents, right? And they had 0 patents all the way through 2016. Peloton, very different case, right? They came out of the gates swinging, right? And they started filing 19 patents to start with, and then they kept on doubling down. In 2010, they filed 18 patents, and they just kept going. And that really is how the enforcement strategy works, right? So that is the playbook, or a good playbook for somebody who wants to enforce their patents and keep competitors out of that market space. So that's one strategy. The other strategy is if you're going to go directly to e-commerce, right? So to me, a great example is Spanx. What they did is they filed 1 or 2 patents in the very beginning, right, in 2005 when they launched the company, and then for a while they didn't file anything, right? Because like we talked about in the beginning, if you're going to be on an e-commerce platform like Etsy or Amazon, you need 1 patent, and you need to be able to send it to Amazon and say, hey, all these other companies I found infringe my patents. Can you please take them down? And Amazon will do that if you have a valid patent. So it's a good idea to file a patent early and try to get a broad set of protection on it, or don't even worry about the scope of protection. Getting something on file is critical and important, I think. So you want to do that. And then as the company grows, right, they had other kind of monetization opportunities. They started licensing. They started making a lot more money, which is helpful in order to support a bigger patent portfolio, right? So they started filing patents more and more on their technology, and I think that's a good strategy. And if you look at, I was watching some interviews with Sarah Blakely, who's the founder of Spanx. She actually filed her own provisional application, so she's really proud of this, right? And she talks about it all the time, that she couldn't afford to hire a patent attorney. Shows she just went to the library, read, like 10 books on how to write a patent application, and wrote one herself. It took her a couple of months, but she did it. And I'm not surprised, right? Like she's a force of nature, as many of my clients are, right? If you're an inventor by nature, you're solving problems, you're figuring things out. So all of my clients, everybody here is capable of writing their own provisional application. I think it's a good idea to protect yourself. And here at this early stage, when you're just starting the company, you can afford to write a broad patent, because if you don't get it, it's okay. You're still patent pending, right? You work towards getting traction, which is the opposite of what Theragun did, right? So they didn't file anything. And then 10 years into the company, they filed a pretty broad patent here in 2016. And to me, that's a mistake. Like 10 years in, you can't be filing broad patents at that point. You need to be specific and try to capture, I call them choke points, right? Things that are all of your competitors are going to copy or need to have. And you got to narrow the scope of that application quite a bit and get strategic with your patent filings. But when you're starting out, you can be pretty broad and then get strategic as you get further along. So I hope that makes sense to you guys in terms of how Spanx and Peloton, both billion-dollar companies, how they've done it. Okay. And yeah, this is again going back to how Theragun, I think, mismanaged their IP, right? And they're paying for it like very significantly in the marketplace, right? It's very tangibly evident that their competitors or knockoffs are just eating away at their market share, and they had to really right size their strategy in like 2016, 2019 timeframe. And it's going to take a while for all those effects to play out in the marketplace. But if they had been more proactive, more thoughtful about filing patents early on and what to file patents on, I think they would have had a much better outcome in the marketplace today. The third kind of strategy is to have adoption by leagues and associations, right? So there's this one company called SIQ. They make a basketball with like a tracking sensor in it, so you can track all sorts of things about like, how high you shoot or what's the velocity of your ball, what is your make rate, and all sorts of stuff, right? Like how many times do you dribble before you shoot the ball? They signed a deal with FIBA to get this adopted by FIBA, which is the International Basketball Sports League. And that's great, right? Like that is market validation. So if you have FIBA adopt or endorse your technology, then it's much easier to get it in the hands of smaller leagues, right? So they have actually leveraged this, and it's in many of the European leagues. And this patent strategy is different as well, right? So this company was founded in 2012, and right away they started filing patents, right? Because as we talked about early on, if you're going to sell to leagues and associations, you better have some patents to protect yourself, or you're just not going to get their interest, right? They're too busy, you're too small, and they're going to say, yeah, like we'll think about it. But having patents, you can really craft a narrative that says, hey, we're the only ones capable of doing this. And if you decide to go with somebody else, you could be on the hook for infringement damages, right? So they're much more likely to work with you and do business with you. So that strategy looks very different. It requires you to file a bunch of patents, get that market adoption, and then as you get more adoption and more money in the bank, you can keep filing more patents, which is kind of what they've done. Okay. And then this is the flip side, I think. So there's this company called Hawkeye. I don't know if you have heard of it, but they do all sorts of tracking in all sorts of different sports. So they use it in baseball to track strikes, for example, in tennis to track when a ball has gone in or out. So they have all this kind of technology in here. Hawkeye is very interesting because they use sensors, cameras, data analytics, and software to predict where things are. They started in 2001, and they have some traction along the way, but they're kind of puttering along until 2011. About 10 years later, they get acquired by Sony, and then the company just absolutely takes off, right? Then it gets adopted by the Olympic Games. It gets adopted by the European soccer leagues, and eventually, like they're a multi-billion-dollar business now. They get adopted by basketball leagues, NBA, WNBA, baseball, soccer, NFL too, right? They signed that deal in 2021. So they are kind of the game in town as far as sports tracking. And Sony acquired Hawkeye in, let's see, this was in 2011, right? So 10 years in, Sony acquired them, and actually they acquired them for reportedly $32 million, which, is a lot of money, but it's, to me, I was like, that's selling it for pennies on the dollar, because I would have expected Hawkeye to sell for something like $300 million or $1 billion, right? Just based on the trajectory and the market adoption and journey that they were in. So Sony got an insane deal, and I was like, how, what happened, right? And when I looked at Hawkeye's patent portfolio, they hadn't filed a single patent. They had filed one, I should correct myself. They filed one patent in 2005, and it was actually abandoned. They never allowed it, and Hawkeye never followed up on this. So from 2001, when the company was founded, all the way to 2011, they had 0 patents, right? And I think that probably beat their valuation down, right? Or Sony used it as a way to have leverage on Hawkeye, and that's probably why it sold for $32 million as opposed to $300 million or $1 billion. And I was like, let me see what Sony's patent portfolio looks like with regards to sports tracking technology, right? So Sony is a big company, but I filtered them down to sports tracking technology. And look at that. They filed 17 patents on this technology in 2005. And they just kept on going. I mean, this is a big company with big resources, right? So if I'm Hawkeye and if I'm advising them, I would say, hey, look, Sony, your competitor, they do the same things. They're just crushing you on the patent filing stage. You got to get your filings up in order to compete against this. Or if you get an acquisition offer, they're going to beat down your valuation on the basis of your patent portfolio. You got to get those numbers up. And if you look at Sony's patent portfolio, I guarantee they use their patents. Like this was filed in 2013, but they have lots of patents like this, like information processing devices for tracking sports technologies or athletic movements. This patent was, in our system was valued at about $2 million, right? So like you probably just need like 10 of these to amount to the entire valuation of the company. Like those 10 patents, if they had filed them, would have been worth so much. So I am sure Sony said, look, Hawkeye, sell to us for pennies on the dollar, or we're going to shut you down because you infringe all of these patents that we do. Might have put Hawkeye in a over a barrel type of position. So these are the kinds of things you got to be aware of. What is happening in the IP marketplace, not just in the commercial marketplaces. So to me, this is a cautionary tale of underinvesting in your IP strategy, right? It kind of came back and bit them in terms of their valuation at acquisition. Theragun or Therabody also underinvested on their intellectual property, and it bit them. They're paying for it right now. Like they're seeing all these competitors. Tough spot to be in. So being proactive and forward-looking and filing patents based on whatever your go-to-market strategy and all those three factors that we talked about, I think is very, very important. So does that make sense to everyone? Do you guys have any questions about that? Any of the things that we talked about so far? I'll give you guys a couple of minutes to type questions if you have them. Okay, well, if not, we'll hang around here for another 10 minutes or so. I had allotted about 10 to 15 minutes for questions if you guys have them. So send those to me, and I am happy to answer them. But in the meantime, we also promised you guys a promo code. So we have also developed a AI driven patent search tool. It's very much in beta, so we're still working on it. But we'll email you a link here. But if you want to visit it, use the promo code Game Changer to get a free patent search. So check that out. It may help you just kind of get a lay of the land. The search tool is not perfect yet, but it's a start. It's really meant to give you the lay of the land as opposed to be a definitive end-all be-all search on your product. So hopefully that gives you guys some additional firepower, if you will, as you deal with competitors and things like that. So I'll stop talking now. Thank you all for attending. Send me your questions via the chat here or the Q&A, and then we'll go from there. And I should say, also feel free to email us. My email is, I'll put this here. Let's see, summer@outlierip.com. Send me an email if you have questions. We also have some PDFs that we've created that helps you kind of evaluate your patent situation, summarizes this presentation. Even if you work with a patent attorney and you have, sometimes you have a hard time reviewing patent applications and giving feedback back to your attorney. So we've created a PDF about that may help you navigate those conversations, or how to think about patents strategically. So send me an email. We'll send you a PDF of that checklist as well, which I think will be helpful to you guys. And we'll send you in a link to the search tool as well. Oh, looks like we have a question here. How can someone overcome a 101 rejection? Good question. There are lots of different ways to go about it. I've written a blog post about this. Let me see if I can send you a link to it. Mm-hmm. So this is a blog post that I wrote. There are a few different ways to get there, I think. You have to, I think, write the patent in the right way is kind of the most important thing. But you want to write it up in a way that you show that your software is an improvement in a few different things, or one of the few different things. So it's an improvement in computer functionality, right? So it's making computers faster, or it reduces kind of the bandwidth that's necessary, or compute cost, electricity usage, things like that. So you want to show that. And if you can't show that, you have to show that your abstract idea is transformed into something that's patentable. And you can transform an abstract idea into patentable subject matter by showing that what you have is an unconventional solution, right? So if there's one way of doing something in your industry and your software does it differently, then you can show that, hey, even though this is an abstract idea, it's actually transformed into patentable subject matter because I'm incorporating an unconventional solution. Or the implementation is also unconventional, right? So like you can argue it that way as well. So those are like three of the ways to do it. There's probably a dozen different ways to do it. Happy to talk about this some more offline if you want, Simon. Just let me know. But there are a few different ways to get there. The key is to write your patent application with these goals or milestones ahead of time, so that you can deal with these rejections when they come at you. Let's see. Any other questions? Yeah, let me know if you guys have any other questions. I finished the presentation, but I'll hang out here in case folks have questions that I can address. And I should say, feel free to shoot me an email anytime if you have other questions that um, require some more conversation. Um, yeah, Andrew, thanks for the question. Let's see. Um, could you explain that some more in terms of, I have plenty of opinions about public disclosure. Um, I'll give you the legal answer first, but if you want to give me some more context, I can try to answer your question more specifically. Um, so the legal rule is that you have 1 year from your public disclosure date to file a patent application. So if you make a blog post about it or do a webinar about this, you have 1 year from that date to file your patent application. And if you don't, then your own public disclosure can be used against you when you go out and file your application. So the patent office can say, well, this invention already exists. Look at your own webinar more than a year prior to your filing date, and therefore your invention is not novel or it's obvious in light of what already exists. So your own public disclosure can be counted against you. Because the rule is, if you think about it, a patent must be filed, must be novel and non-obvious over everything that came before it. But they do give you a grace period for your own public disclosure, so you don't, you can talk about it and see if there's a market for it before you file a patent. So that's the legal rule. You must file your application, whether it's a provisional or non-provisional, within 1 year of your public disclosure date. So some of my clients will, do disclosures and talk about their invention publicly. And if there is a market for it, and if there's demand and interest, then they'll come talk to me and file a patent application. Um, but I have other clients who are like, well, the invention is so self-evident, right, that if somebody saw it, they could easily, rip me off and start copying it. So they want to file a patent first before they do anything else. That's something to think about as well. Um, most people, I would say, in terms of people I work with or my clients, and best practices from an industry perspective, is to file a patent first, usually a PPA or a provisional application, and then do a public disclosure. It usually gives you much more protection, right? Because let's say you publicly disclose your invention, and then you somebody else copies that invention, right? And comes out with a product like that, and then you filed your own patent application. Now that person who beat your filing date might have avoided infringement, right? Because um, uh, anything that comes before your patent filing date is considered non-infringing. So you do leave yourself exposed for that period of time. So that's why it's best practices to file the patent first, then do your public disclosure. But if you wanted to do it other way around, I'm not opposed to it. Just know that 1 year rule. There's no way around that 1 year rule if you miss it. Okay. I'll hang around for one more minute in case anyone has last minute questions. But if not, yeah, shoot me an email, get in touch with me. Happy to talk to you about the AI search tool that we have, but also if you're interested in patent pending made simple, using our software to help you write a provisional patent application. Happy to talk to you about that as well. We've had a lot of people use it in the last 6 months with a lot of great success. And it's a great way to minimize your early stage patent costs as well. All right, we'll end the live stream here. Thanks everyone for attending. I appreciate it. If you have any questions, feel free to reach out anytime. I appreciate all of you guys. Thank you.